All right, we're gonna spend the next little bit going through this process. And I will say that this is a little bit of a taint from me in terms of trying to make this easy and simple. The Title IX regulations are 27 pages with the commentary. They're like 2,000 something pages. But this is my suggested effort to make this process streamlined and simple and not as complicated as it may have felt in the beginning. Okay, so step by step, step one process. These are materials. This entire presentation is in the binder, which I'm going to be taking back, so you can follow along in the binder as we go through. And there's also a flow chart, which, if you like visuals, you can kind of see that under tab 2 and kind of be able to walk through step 1, step 2, step 3, etc. So the very first step in this entire process is that someone reports something that is sexual in nature, okay? And it might not even be a report, maybe it's an observation. But somehow knowledge comes to the LEA, that would be the Title IX coordinator eventually, about conduct that could amount to sexual harassment. Okay, it could be through a direct report or observation. Maybe a student witnesses and reports what they saw or heard. Maybe the complainant reports. Maybe a parent calls with a complaint. Again, any employee who becomes aware needs to report it. I've already said that. Another way that you could receive information about a sexual harassment complaint is that the person just files a complaint. It may be that a parent looks on your website, finds a complaint form, and sends in the complaint, and you had no idea that it was happening. Okay? So in any event, step one is you get information about a complaint. Okay? Stop everything right here. Yeah, question?
Yeah, so the janitor who fails to report is personally liable.
No, it's the school district.
The school is.
Yeah, so if a janitor fails to report up the chain, and it turns out that there's some sexual harassment occurring at the school that the janitor knew about, and the school district didn't because the janitor didn't tell anyone, the school district is still on the hook because an employee at the school knew. So this is why it's so important to tell your employees, tell us, talk to the supervisors. Okay. Step two, before we get to step two, after step one, stop everything. This is where a lot of schools are kind of getting in trouble right now, and not in trouble legally. There haven't been any lawsuits in Utah that I'm aware of over these new regulations, but it is a shift, a dramatic shift in the way we've always done things when it comes to conduct at school. Stop everything in terms of beginning an investigation. Usually, you hear about something, you investigate, because you're trained as administrators to do something about it. But with these new regulations, you stop, okay? Before you do any investigation, before you suspend, and follow these next slides, okay? Make sure that, how many principals? We have principals, building principals, how many? All of you. So stop, contact your Title IX coordinator before you continue with an investigation, okay? In your binder, there's a tab 3 that goes through these questions. Building principal, it is okay to conduct, I'm going to call it a screening, okay, as opposed to an investigation. Obviously, you're going to have enough information to work with your Title IX coordinator and determine whether or not it is sexual harassment. So you're going to need to know what happened, where it happened. Has a respondent done this before? Going to that pervasive question. Are you in a dating relationship? Going to that dating violence question. And then have you reported to CJC simply because that's not required by Title IX, but that is required by law, that we report information that could be sexual abuse. Again, this is not an investigative interview. This isn't a sit down, write a statement. If you do want them to write a statement, make sure that your paper says screening information, because it can't be an investigative interview this early on. You just need to have enough information to know what to report to your Title IX coordinator. So this is very small print, but it is in tab 3, so you can follow along in the binder. Here are some questions that you and your Title IX coordinator might want to go through together, or just kind of have on your desk so you can kind of look, do I call my Title IX coordinator? 1, does the allegation involve an employee offering a benefit in exchange for a sexual favor? That's that first category, quid pro quo, right? If the answer is yes, call your Title IX coordinator. If the answer is no, go on to the next question. Does the allegation involve conduct that is severe? If the answer is yes, go on. If the answer is no, then jump to question 6, because then you're going to get into the sexual assault piece. So this questions 2 through 5 are all questions in determining whether or not there's a hostile environment being alleged. And remember, you're asking these questions of yourself as if the allegations were true. Not because that means you're going to run out and suspend a kid, but you're just trying to decide whether or not to follow the Title IX process. So you have to say to yourself, if this is true, is it severe? If this really happened, was it pervasive? Okay, is the allegation that it's pervasive? If yes, then continue with the SPOO analysis. If no, go to question 6. Number 4, does the allegation involve conduct that is objectively offensive? If yes, go on. If no, go to question 6. Again, SPOO, just remember, severe, pervasive, objectively offensive. Those are the 3 elements that have to exist in order to be a hostile environment. If you don't have physical touching, and you don't have stalking, and you don't have an employee involved, and the only thing you really have is this hostile environment. So severe, pervasive, and objectively offensive. Okay? Is the complainant being denied access to educational benefits as a result of the conduct? If yes, call Title IX, because 1 through 5 get you to SPOO. If no, then you've got to ask whether the alleged conduct is sexual assault. If yes, then you're going down Title IX. If no, go to the next question. Is the alleged conduct dating violence? Is the alleged conduct stalking? Is the alleged conduct domestic violence? If you get to know at the end of all of these questions, but it's some conduct that is misconduct, handle it. Do something about it. Don't ignore it, but just, you don't have to necessarily follow Title IX process. Okay? Some asterisks. Severe, pervasive, objectively offensive are not clearly defined. We've talked about that already. Sexual assault is unwanted touching with an intent to receive sexual gratification. In the binder, the next page, just behind that screening question, has definitions too. So as we go through yeah, Cody.
Okay, Heidi, do you have, so this is great for principals to look at as they look for their Title IX coordinator, but just about a paragraph ago, you said we need to be intentional about informing every staff member of what's reportable. Do you have something similar that principals could go back and in a one-pager say, all staff members, coaches, janitors, bus drivers, these are the indicators that you need to bring forward? Because sitting down and having a 2-minute dialogue with the staff members is out the window, but giving them step-by-step, something like this, that we could have principals and vice principals go back to all district staff members or building staff members and say, these are reportable items. By God, you will come to me.
I don't,
you have
but
something like
easily
that?
created. I don't, but easily created. Because my recommendation would be the lowest level offense that has anything to do with sex.
Yeah.
You report it. But I'm happy to work to create something like that. But I don't have something like that right now. Yeah.
Thank you.
But I would undercomplicate, which may result in an over-report, as opposed to overcomplicate, that might result in an under-report.
And that's the worry, right? So.
Yeah, yeah. Okay, so that's step 2, the initial screening. So step 1, you get information. Step 2, you go through this initial screening, decide which avenue you're going to go, Title IX or your regular code of conduct, which does not include these very prescriptive processes. Okay. So step 3 is that the Title IX coordinator meets with the potential complainant, and that is required in the regulations. So Title IX coordinators would then reach out to the complainant and say, I understand this happened, please come and meet. It could be a telephone conversation, and it could be with the parent. Most often it's with the parent, right, for minors. And it's an opportunity to do 2 things. 1, to explain how to file a formal complaint, and secondly, to offer supportive measures, to make sure that there are things that are being offered to the complainant that help the complainant feel safe at school. But again, also to say, here's our process, here's the complaint, here's what it looks like, would you like to file one? This is different than what it used to be, and different than what it might be in the future, But currently, right now, the only Title IX investigations that you have to do are if you have a complainant signing a formal complaint. If the complainant does not want to sign one, then Title IX coordinators can decide, I will file a formal Title IX complaint on behalf of the complainant because this is really serious. Keeping in mind that you may have an unwilling complainant, and that might be hard to get evidence from that person. Supportive measures may include, just some examples, counseling, extension of deadlines or other course-related adjustments, maybe if it's an employee, modification of work schedules or class schedules, altering work arrangements if it's an employee or student employee, a safety plan. That's a very important supportive measure that a lot of schools utilize for lots of different reasons. Safety plan could include things like having a safe person, a safe adult to talk to if you feel threatened, making sure that student complainant and her respondent aren't in the same hallway together. Maybe it allows the student to leave class 5 minutes early to get to their next class so they're not inadvertently running into the kid in the hallway, the student, the respondent in the hallway. Safety plan would include an opportunity for the complainant to leave class and go talk to a counselor if the complainant is feeling anxious. It could be a lot of different things. Work with your counselors to help create safety plans.
Sorry.
No, you're good.
One more thing, we had this happen, so, and then we're gonna go back, when you were saying that we had a situation where they did not want to file a formal complaint. On the benefit of the district or the administration, how should we document that? Because in the case that 3 months later, someone comes back and you wanna make sure you cover yourselves for your coordinator, and Roy, what did we end up doing? They didn't want to file it, we just documented it as a non.
I just made a journal entry in my Title IX folder and just documented the whole conversation that I had with them and presented the, just said I presented the options, but then they said, no, we don't want it, we're not interested in it.
Yep, and that's fine.
Anything further you do, because
Offer those supportive measures,
some
document
of our
those supportive
smaller
measures.
communities, they don't want to get into the weeds, but then
Right.
things progress, or they just change their mind months later. And then is there a statute of limitation on coming back to that?
There's not, but the Title IX coordinator, it'd be a good idea to reach out to the complainant periodically, once a month. How are things going? Are you still feeling okay? Let us know if things change. Understanding, of course, that evidence gets stale if it's so long after the fact. Witnesses go away, documents get destroyed, and so helping the complainant understand that if you're not ready right now, that's fine, we'll make sure you're safe. We can't take disciplinary action against the respondent. If you change your mind, let us know, but know also that it will be harder to do an investigation down the road than as opposed to now. And then just having those check-ins to make sure the complainant is feeling safe. Yeah. And documenting that, yeah. Okay. So step 4, the formal complaint is filed. Okay, just again, repeat. Step 1, you have information. Step 2, you do that quick screening to make sure, decide what process to follow. Step 3, Title IX coordinator meets with the complainant to say, look, this is what the process is. Here's the formal complaint. Would you like to sign it? Step 4, the complainant files the formal complaint. It could be done by the complainant or the Title IX coordinator. And it might be a good idea in policy to determine in what instances the Title IX coordinator will file a complaint when there's a complainant that doesn't want to. There's nothing in the regulations that says one way or the other. So you can determine, some LEAs say if there's a physical threat, then the Title IX coordinator will file. Or some LEA policies say if it's pervasive and affecting a lot of students, the Title IX coordinator will file. But again, the difficulty is if you have a complainant that doesn't want to file and doesn't want to have anything to do with it, then it's going to be hard to get an interview with that complainant, and it's going to be hard to get the evidence you need to support a finding of responsibility. So that's sort of the things you have to weigh. Step 5 is an emergency removal if it's warranted. So the next thing you should do right after you get that formal complaint is determine whether an emergency removal is warranted. Under the current regulations, it is only warranted when it is based on an individualized safety and risk analysis that an immediate threat to the physical health or safety of any student justifies removal. The basis for the removal must be documented, and the respondent must have an opportunity to appeal that removal. There's nothing in the regulations that says you have to do a formal risk assessment. Nothing in the regulations that explains what an individualized safety and risk analysis looks like. I know some LEAs who use risk assessments regularly will do a risk assessment, but often those risk assessments require the respondent to admit and own responsibility for the conduct. And where you're at the very beginning, and if the respondent is denying the conduct, it's a little harder to do some of those more formalized risk assessments. Sometimes this is just a review by the principal, what the student's conduct has been in the past. If there is a verbal threat of harm to the complainant, that ought to be taken into account. But most of the time, an emergency removal is not warranted under these current regulations. Note the specific language is a threat to the physical health, not emotional health. Okay? So currently, right now, under present day regulations, you need to be able to articulate what that threat is and why you're removing the student immediately during the process of the investigation. Step 6, then, is to send the allegations. Send a notice of the allegations to the party. So after you have the formal complaint, which should have a description of what happened, and after you determine whether or not to remove the respondent, then you send a notice of a formal complaint, which has these things. In tab 5, there's an example of what the notice of formal complaint looks like. These materials are going to be provided to CUES, and there's templates that you can just plug in your information. So tab 5 is a template of that notice of allegations. So again, this is intended to streamline this process, making it as easy as possible for you. When you get an allegation, there are certain things that have to be in there, and this is basically your boilerplate language. You just have to plug in the information that applies to your specific situation. Okay? Tab 4, sorry, I skipped that. Tab 4 is a template for a formal complaint. So you can utilize that complaint form and put it on your website and let people get on and fill out the information. You can print it off and give it to a parent, however you want to use it. But that's an example of what a complaint looks like. Okay? And the notice of allegations. Note that you have to identify the specific allegations in the complaint, the notice of complaint, excuse me. You have to include this paragraph or a line that says, innocent until proven guilty, in the language that the regs have. That the respondent is presumed not responsible until a determination has been made that the respondent is responsible. You provide information about the process, the standard of evidence that will be applied, directives not to retaliate, and information about an offer of an informal resolution process. Now, this is a really good way to address your requirements under Title IX without having to go through the lengthy process. And that's the informal resolution process, which we'll talk about shortly. Okay? There's no specific requirement for how this process looks. Tab 6 and 7 are processes that you can use, but by all means, feel free to vary and deviate from them. Okay? So, step 7 then is to interview. You start your investigation. Your investigator starts the investigation. Okay? At least 2 to 3 days prior to the initial interview, and that number is not written into the regulations. What it says in the regulations is that you need to provide sufficient notice in order to give the parties time to prepare. So 2 to 3 days is probably sufficient. A week, that's probably more than you need to give. An hour is probably insufficient. So 2 to 3 days is that sweet spot of giving the parties notice of the interview in order for them to have time to prepare. And that notice of the interview is on tab, starting to lose track of my tabs once I get past 7. Tab 12. Okay. Tabs 8, 9, and 10, and 11 I'll talk about in just a second. Actually, we already talked about tab 10. Tab 10 is the notice of emergency removal. So if you do determine that the respondent should be removed under the emergency removal provision, You use tab 10 and just plug in the information into that template. Okay, so that's what tab 10 is. Tab 11 is the notice of administrative leave. Now let me just comment on that real quick before we jump back to interviews. Emergency removal for students is only warranted where there is a threat of physical harm. Putting an employee on administrative leave is totally at your discretion because you're still going to pay them, right? So you're not taking anything away from the employee who you're placing on administrative leave during the course of an investigation. That is pretty standard. Anytime you're investigating an employee for conduct issues, a lot of schools will put that employee on paid administrative leave. So tab 11 is a template to put an employee respondent on paid administrative leave. And you don't have to determine that there's an emergency to do that with employees. Okay? Tab 9, sorry, I'm kind of going backwards now. Tab 9 is a notice of dismissal. And we'll talk about when you can dismiss in just a minute. But there are a couple of instances when you have to dismiss a Title IX case and when you may dismiss a Title IX case. And if you look at tab 9, turn to that right now. I guess we'll talk about it right now, now that I'm talking about it. You turn to tab 9, you'll see that the page is filled with a whole bunch of different colors, highlighted colors. You can see if there's 3 different reasons that you can dismiss. If it's reason 1, use the language that's in green and delete the other 2 paragraphs. If it's reason 2, use the language in blue. If it's reason 3, use the language in purple. Again, trying to make this as easy as possible so you can just adopt whatever it is, the reason that you're dismissing, and then use the rest of the letter to send out. Okay, now we're about to notice of interview, which, like I said, is tab 13, 12, what did I say?
12.
12, thank you. This notice of interview has all the information that users are required under the regulations. It says you are asked to come to this meeting at this time. Here's who is going to be in attendance. You may bring an advisor or an attorney. A lot of students bring their parents. That's totally appropriate. They can bring attorneys. Note something that in a lot of situations where a party, an employee or a student brings an attorney, the school district will often invite the school district attorney to be present. You don't have to do that in this situation because the school district is not a party. The school district is not at this point adverse to either the respondent or the complainant. The school district is the investigator right now. And so if the complainant wants to bring their attorney, that's great. And the school district does not have to have an attorney. There's nothing the school district is doing that is going to incur liability. In fact, you're doing your job. Same with the complainant. So if the respondent or the complainant want to bring an attorney, great, let them. The investigator can go ahead and conduct their questions with the attorney present. If the attorney turns to the student and says, don't answer that question over and over and over again, then as the investigator, you'll have to say, if I can't get any information, I can't investigate. But you don't have to threaten to call your attorney because, again, you are not a party. No one is looking at you as an adverse party to the case. In fact, you should be going in as an investigator as neutral and objective and impartial as you possibly can. You're looking at this to see what happened.
You typically send these letters, I mean, it's addressed to the student or the employee. You typically send them directly to the student, or do you send them to
No,
the parents?
to the parents, yeah. So title or tab 12 is addressed to respondent and complainant. Send it to the parents, especially if they're under 18. If they are 18, you may want to specify in your policy that communication will go directly to students who are of legal age, something like that. But most of the time it's with the parents. They can be emailed, they can be hand delivered. There's nothing in the regulations that requires they have to be delivered in a certain way. So email is fine. No, you can do it. Here's the thing. I take that back. You can, because the notice of allegations already has information about who's the complainant. You have to identify the complainant. You can't conduct a Title IX investigation without identifying the complainant. So you could send this one letter to both respondent and complainant. Alternatively, you could take out the word and complainant or respondent at the beginning and send one to the complainant and one to the respondent, which actually I would recommend because you're probably going to have different dates and times, or at least times. You're not going to interview them at the same time. So use this template and just delete one or the other, either complainant or respondent, when you're sending it to the parties. Does that make sense? Thanks for clarifying. Okay, so step 7 is sending that notice and interviewing. You interview the parties, you interview the witnesses, you collect evidence. It could be security cameras, it could be statements, it could be police reports. Like I said at the beginning, a lot of the conduct that you're going to be investigating will be criminal, and so there might be law enforcement involvement. And in that case, you get to pause until law enforcement finishes their investigation, because law enforcement needs to be able to ask questions of kids without interference from administrators, so they can move forward with the prosecution. Any information that law enforcement gets in the form of statements can be requested under GRAMA, the Governmental Records Access Management Act. And if you develop a strong, positive relationship with your law enforcement agency at the outset and help them understand this process, it shouldn't be difficult to get a copy of a statement or the police report, okay? Now, let me say something about CJC. That's different. Any interview that CJC conducts with their forensic interviewers is protected under the highest classification of privacy under the law. Nobody has access to those interviews except specifically delineated people in the law. However, there might be instances where you have a detective who's conducting the investigation criminally, who's allowed to witness the CJC interview and take notes about what the complainant is saying. And those notes are not CJC interviews. Those are notes of the detective. And those notes may be shared under GRAMA. Some agencies are not going to allow the detective, some CJCs won't allow the detective to listen to the interview. They'll just give the detective the interview, and that is still protected. So it varies from jurisdiction to jurisdiction. Work with your law enforcement agency and make sure they understand your responsibilities under Title IX, and help them understand that to the extent that you don't have to re-interview people, it's going to be better for everybody. So if you have someone who's already interviewed the complainant and you can get that police report and you have no further questions, you might be able to satisfy your obligation. Is that what you're going to ask? Yeah. Okay. Other questions about, well, I mean, we'll talk a little bit more about working with law enforcement in a minute, but I found that the better relationship you have, the better the detective understands what you need, the more likely you are to get it quickly. They only have to finish their investigation. The prosecutor does not have to actually prosecute the case before that police report can be accessible to you. The important piece is that there's no interference with the investigation. Okay.
So how does this work with the resource officer? I mean, when you're meeting with the client and they say something, at what point do you bring them in? At what point do you?
As soon as you have information that it could be criminal, I'd go back to the screening. Back before you're even down this road, if you have information that you're not sure, talk to your resource officer and say, is this something that is criminal that you're going to want to handle? And they'll let you know. Okay. Step 8. First 10-day review of evidence. So after you've done your investigation, you've collected evidence, documentary evidence, security camera, police reports, you've talked to people, you've taken notes. At that point, then you as the investigator, whoever you are, sends all of that evidence to both parties. So whether it's a summary of interviews that's just documented or written down, if it's text messages that have been sent to you, you can print those, take screenshots of those text messages, and send all of the evidence to both parties in an electronic file. And tab number 13 is a template for sending that evidence information. It's a cover letter. Again, not required under the regs, but before just sending an email with a whole bunch of attachments, it might be a good idea to explain what they are and what the next step is. So both parties get to see everything that everybody has said, everything that you have seen in its raw form. This is not your summary or your analysis. It's, here's the evidence. And either party has an opportunity to respond and say something like, hey, Mr. Investigator, you didn't talk to any of the witnesses that I recommended that you talk to. All you talked to were the respondent's witnesses. I would like you to interview the witnesses that I recommended. Or, conversely, Respondent might say, Mrs. Investigator, you didn't look at the text messages that I mentioned in my interview, and I think that's important. So look at those. I will tell you, in the, I don't know, dozen Title IX investigations I've been involved in, no one has actually said anything during this 10-day process. But I think as attorneys become more savvy and understand these laws and these rules, then they may start to ask and demand further investigation. But usually it's just a 10-day waiting period. So step 9 then is the investigative report. After that 10 days has passed, and assuming there is no further request to investigate more or to look at anything else, then you write up an investigative report. Okay? And that it looks like tab 13, 14. Like I said, I don't have my tabs in front of me on this particular binder, but it's the one that says final investigative report. And it has a cover letter on it. It can be sent by the Title IX coordinator. It can also be sent by the investigator, but it explains, now, here's the investigative report. Here's the next step. An investigative report summarizes all of the evidence that's reviewed, and with a little bit of, it could have the investigator's analysis about credibility, but it doesn't have to. And then this report is sent to the decision maker, someone else, and to the parties again. And the parties have another 10 days to look at the report and comment with questions in the form of a cross-examination process to each other, okay? Once the final investigative report is written, it's out of the investigator's hand. So those of you who are investigators, you finish your report and it's done. The template in here hopefully makes it easier to write a report. If many of you have written a formal investigative report, it might look big and detailed, and it is, but again, if and when it's litigated, you'll be glad that you have the detail. But it's, again, just plug and paste. So put in the information that is already created, the entire form. And this is, let me just repeat, Heidi Alder's recommendation is lots of different ways to write investigative reports. So this is certainly not something that is required by the regulations to use this particular document. There are many ways to write reports. This is how I like to write reports when I've done investigations, and those of you who know, I did investigations with UPAC, so I've done several hundred investigations in the course of my profession, and this is how I like to do it. But you are welcome to rearrange or do whatever works for you. Okay, this is just a template that makes most sense to me. So once that report, like I said, goes to the decision maker and is shared with the other parties again, the parties have 10 days to submit cross-examination questions that are fielded by the decision maker. So respondent wants to ask complainant a question about how complainant knows the respondent has done this to 6 other girls. That goes to the decision maker first. The decision maker says, yeah, that's relevant, and sends it to the complainant, and the complainant will respond. Okay? Again, I haven't seen parties take advantage of this. A lot of parents are just like, okay, here's this report, what do I do with it? Sometimes a parent will respond and say, I just have one more thing to say about my kid and how well, she's been doing. She responded, and she understands what happened, and she is sorry for her mistake, and she's been excelling in school, and she's been doing awesome. That's fine. Take that, consider it, share it with the other party. The whole point of these regulations is transparency and ample opportunity for all parties to see what the final decision maker is seeing. Okay. And then you get to making a final determination. So tab 14 is a sample of an investigative report, and this is the one we're going to walk through after lunch. Tab 16 is a decision-making, final written determination. Again, template. And then the next tab is a sample of what that looks like. And there are certain things that, according to the regulations, have to be included in this final written determination. So while the template that I've given you is still open to be moved around, this is a little bit more prescriptive under the regs than the investigative report. You have to have these 8 elements in the final written determination somewhere, okay? The identification of the allegations, a description of the procedural steps that were taken, all the way from the time the formal complaint was filed through the time that came to the decision maker's table, findings of fact supporting the determination, conclusions regarding the policy that was violated, if any, a statement of rationale for the result of each allegation, any recommended disciplinary actions, and then any remedies to restore or preserve equal access, so anything to help the complainant, and finally, procedures for the appeal. So all of those things have to be in the final written determination somewhere. The template in the binder is one that includes all of these things. And then the appeal. Step 12 is the appeal. Offer the appeal. And that's written right in the final determination, so parties know what that process is. There are only 3 bases for appeal under Title IX. They are, one, that there was some procedural irregularity that affected the outcome of the matter. So if someone got a notice of interview 1 day instead of 2 days in advance, and your policy says 2 days, but it would not have changed the outcome, that's not a basis for appeal. So you have to have some procedural irregularity that would have affected the outcome. New evidence that was not reasonably available at the time the decision was made. If someone at the end of the entire process says, as maybe the respondent, wait, I have this text message that you didn't look at, and the text message was always there the whole time, and the respondent had 10 days to bring that up during a review of the evidence, and 10 more days to bring it up during review of the investigative report, it's too late on appeal to say, oh, well, I had this text message that would have, totally made it clear that I didn't do this. If, however, the text message wasn't available at the time, maybe a friend brought it to the respondent and say, hey, remember when you sent me this message? It's not on your phone anymore, it's on my phone. And the respondent can explain why it wasn't available during the investigation and it is now. That might be a fair basis for appeal. And then finally, the third basis for appeal is that the Title IX coordinator or the investigator or the decision maker had a conflict of interest or was biased against the party that's filing the appeal. So saying, I just don't like the outcome is not a fair basis of appeal. They have to articulate one of these reasons. And if you get to tab, there's a template for an appeal, and you can see that it has specific reasons, 18, that they can check as to what the reason for the appeal is. Okay? And tab 19 is just simply notice of appeal. Once you receive an appeal request, then a notice to the parties has to be sent. We received this appeal request, here's the reason for the appeal, and here's what we're going to be looking at. That's tab 19. And then tab 20 is a template for a final decision after the appeal has been made. Okay.
Who gets to decide if the appeal is for a qualified reason?
The appellate officer, whoever that is. Okay. Often, I guess it's the Jason in this case. The accused decides to be the appellate body.
I'll delegate to Grant.
Any questions? Okay, I'm going to rewind in order of the tabs and go back to tab 6, 7, and 8 as we talk a little bit about this informal resolution process. Okay, so go back to, so sorry, you were wrong. Tab 6, 7, and 8. Yep. So starting on tab 6, okay, this is a notice of the informal resolution process. At any time during this entire charade, if you want to call it that, before the final decision is reached, okay, the parties can enter into an informal resolution process. That means that they can say, stop whatever is happening in the process. We want to, I'll just call it mediate, okay? We want to come to the table and have a kumbaya and not have to decide that someone is responsible or discipline's going to happen. We just want it to end. The notice of allegations has to include a paragraph about the informal resolution process. So it's a good idea to send this tab 6 right along with tab 5 in the same email, in the same letter, because it outlines here's the process. And like I said, there's no prescriptive requirement for what has to be in that process. What tab 6 is a suggestion that might work. This is a sort of borrowed from lots of different educational institutions around the country. I looked at some that I liked and thought this seems like it would work for K-12, and it has worked in the districts I've worked with. But feel free to modify this process. If you do, just make sure you modify the document so that it reflects whatever your process is going to look like. This process is a little bit more like a mediation, where the parties come together, but they do not have to be in the same room. That's not always helpful when you're talking about kids. Coming together meaning you have a facilitator that's talking to the complainant saying, what do you want out of this? And then going and talking to the respondent and saying, tell me what you want out of this. And then coming to some resolution that both parties can live with. That's likely not going to include the respondent saying, I did this, I'm sorry, I will accept a suspension for the rest of the year. That's typically not going to happen. The informal resolution process does not require, nor would I recommend should you include, an acknowledgement of responsibility. That's what the whole Title IX process is supposed to be for. And if parties are going to say, I don't want to go through this process, they don't have to, but you have to help the complainant understand that probably means that you're not going to get this kid kicked out of school forever and ever. If you want that, if that's what the complainant is wanting, then we need to go through this process. Both parties have to agree to do this informal resolution process. This is a great solution for elementary. If you feel like you do have a Title IX situation in elementary, you can't get around it, this is a great solution, because most of the time the parents are saying, I just want it to stop. I just want the kid to keep his hands to himself or herself, right? So you sit down and you have things written out that we'll kind of walk through. Yeah?
So how do you just, I might have missed something here, but if the complainant, or let's say they, like you said earlier, they didn't want to file, it's a sexual assault, whatever, and we do, so we file it, then who would the informal resolution address? Because at that point, it's our complaint, I guess.
Right.
But if the victim,
Right.
if you will, says, I want to finish it, I want to be done, we're the ones that filed the complaint because on their behalf,
Right.
then there wouldn't be an informal resolution. We would follow through.
That's a great question. And I would say maybe just a little bit, I think you're right, but I would say maybe just a little bit reversed. That if you feel like the situation cannot be resolved through an informal resolution process, then file the complaint. If you feel like the situation could be resolved through an informal resolution process, tell that to the complainant and let the complainant know, look, this is a rigorous process. We understand that this is maybe nerve-wracking for you. You don't have to go through the entire thing. One option is to address this through an informal resolution process, and that might motivate the complainant to file and then ask for that informal resolution process. But you're right, if you as a Title IX coordinator feel like this is serious enough, we're going to file this complaint, it doesn't make a lot of sense to force the parties into an informal resolution. Okay? Looking at tab 7, it's again a template for an informal resolution agreement. Following whatever process you end up adopting, there ought to be something memorialized in writing. You ought to have some sort of written agreement that outlines what the parties have come to. And that agreement looks a little bit like a settlement agreement. For those of you who've done settlement agreements, and I'm sure Casey's looked at a million settlement agreements, they have sort of a background, a history of what's happened, and then the terms of the agreement. Like, what is it the parties are going to agree to? Tab 8 is a sample of what that could look like. If you turn to tab 8 and jump to the paragraphs under terms of the agreement, you can see that they could be things like, respondent agrees to stop texting complainant altogether until such a time as complainant is ready to establish a friendship. This sample is based on the hypothetical that we're going to get into after lunch. So it'll make more sense once we go through the scenario. But you're welcome to look at the sample for ideas as to what kinds of things might be the terms of the informal resolution process that you engage in. And then there's the standard confidentiality, breach of agreement, etc. If the parties enter into an informal resolution agreement, and then one of the parties breaches or violates the terms of the agreement, then you can take disciplinary action outside of Title IX. You don't have to do this whole thing all over again. Because at this point, there's a breach of this agreement that's in place that both parties have signed on to. They have agreed to comply with the terms of the agreement. If one of them breaks that agreement, then you can have your regular disciplinary process. It would be a good idea to have written into the agreement what happens if there's a breach. Okay, so that's the end of the process. Again, it wasn't horrible, right? But hopefully this binder will help you walk through that. Tab 1 has that whole PowerPoint. Tab 2 is a flow chart to kind of help you walk through it. And then tabs 3 through 21 are all of the documents that you'll need throughout this process at any point in time. Yeah?
Updated ones, the ones that we have doesn't match your PowerPoint.
Of the slides? Oh, I'm so sorry. I will send an updated one. I'm going to send this electronically to Jason. I'm going to collect these. These are for training purposes, but I will send them. Thank you for pointing that out. I'll make sure that what's in there is in the electronic stuff that I sent. Okay, yeah, thank you. Sorry about that. Okay, any other questions, comments? Okay, what time should I'm going to jump into,
We told them to bring lunch at 11:30, but
okay.
that means probably 12.
Okay, should I just keep on going until I'm interrupted?
Yeah, we're gonna just have it in here, so we'll just watch and bring it right up to that table, so.
Okay. Well, we'll move on just to try to cover this. Hopefully, I was hoping to get through all the next stuff before lunch, so we'll see how it goes. Yes.
A couple questions. When you, that screen where you are making sure you have every title assigned, you did at the very beginning.
Yes. We'll go back to that.
Is there one where you wouldn't want the superintendent, or you, like in our district, we're big enough that and we've talked about this quite a bit, but Mike Willis is our Title IX coordinator, he's our assistant superintendent. Nolan Anderson is our student services director, so he could be the decision maker, or I could have my BA be the decision maker, or I could be the decision maker, but I think if I do it, it kind of throws out that appeal.
Unless you have Q's be your appeals person.
Right, say that again?
Unless the Q's is
Have
the,
maybe me be that, because I'm that anyways, kind of?
yeah.
So,
Yeah, so a lot of, some of the districts that I've worked with, and obviously it ranges in size. I get most of your districts are much smaller than some of the ones along the Wasatch Front. But superintendent is the appellate person. The Title IX coordinator is an assistant super or someone else in the district office. Investigators could be principals. A lot of them have principals as investigators. Could also be any other person in the district office. If you have a student services or an HR person, sometimes it's one of the same. That person can be the investigator. And then the decision maker could be, I would recommend the decision maker be someone at the district as opposed to a principal. But again, it's not uncommon to have a principal be an investigator in one case and a decision maker in another. Just someone who understands what's happening in schools. You wouldn't want to assign a teacher to be a decision maker over a situation happening at the school. But it really can be any employee in the school district. Okay? And there can be shared roles. The Title IX coordinator can be the investigator. Okay? The decision maker could be the informal resolution facilitator. That person can carry on a whole lot of roles. The the appeals person should be someone independent from it all, just because it's hard to take on a role throughout the process and then be an objective, independent appeals person. But you could be creative and be
Did you just say
yourself.
that the Title IX coordinator could also be the informal resolution?
Yes,
That one?
that too. Yep.
Sorry.
Okay. Any other questions about the process before we talk about investigations? Okay. All right, jumping down to, you can you keep your binder open, look through it, that's fine, but we won't use it again until we get to this scenario. We're gonna talk about investigations. We're gonna cover 4 areas before we jump into the scenario. 1, bias and conflict of interest. Secondly, working with law enforcement. Third, just general tips for investigations and interviewing. And then finally, investigating for credibility, reliability, and relevance. Okay, so that's where we're headed until lunch. Bias and conflict of interest. So there are 3 bases for appeal, as we just discussed. One of them is if anyone in the process is alleged to have a conflict of interest or a bias that would make their role adversely impact the outcome for the person appealing, right? So it's important that we make sure you're void of conflicts of interest and bias. Conflicts of interest can be tough in a small community, without question. It doesn't mean that you have to be a stranger to those you interview. And make that clear. You might have a parent or a student who is accusing the investigator after the fact, when it's all done, of a conflict of interest because the investigator lives next door or goes to the same church as the student. It should be transparent up front. If there's a concern, the parent should raise it up front. But in a small school district, you're going to have to let parents know that unless there really is some conflict, I would say a relation, like a family relationship would be a problem. Maybe an ecclesiastical role over one of the parties might be a problem. But other than that, you live in the communities you work in. You're going to be friends with the parents of the kids. You might have some 3rd or 4th cousin relationship, and that's okay, all right? You just have to be objective. Consider the following. Can you be objective if you're the investigator, if the respondent is your daughter's boyfriend? No. Probably not. That's another one that's probably going to be hard. Can you be objective if the complainant is your next door neighbor since you were born? Maybe. Depends on the relationship you have with the family. If you feel like and bounce it by someone else. I mean, it's always helpful to get another person's opinion. Is this, like, if it was published in the local paper, would this look like a scandal? The investigator lived next door to the complainant. If it's not that big of a story, you're probably fine. Can you be objective in gathering information? What about, can you be objective if the respondent is your niece? It's going to be a little harder. Can you be objective if the complainant is a member of your church congregation? Depends on what your role and relationship is with that person, right? If there is a conflict of interest and you're a really small district and you don't have anyone else to investigate, then call Jason. Call other districts. Try to bring in someone from outside. Let's talk about bias for a minute. We all have them, every single person, because we have experiences in our life. We grew up in a certain way. We've seen certain things. We all have biases. That's a matter of fact. Just know what they are. Be aware of your biases. And when it comes to investigation, be aware of these 4 types. Okay? This is more of an awareness than an effort to change your biases. It's hard to do that. But when you're aware of your biases, it helps to minimize the impact. So association bias is when you tend to believe those you associate with someone that you know or an experience that you had. For example, say the complainant looks just like your nephew. Okay? And a lot of these are unconscious, but just as you hear about these, think about them when you go into your investigation. Are you more likely, when you walk in and say, oh my gosh, this kid looks just like my son or my nephew, is that going to lead you to a tendency to believe what this person is saying? Or maybe your nephew's a real pain in the butt, and so you're going to not believe what the person is saying. Again, awareness is key. Maybe your sister was sexually assaulted when she was in high school. Is that going to lead you to believe the complainant over the respondent just by virtue of the fact that it's someone who's alleging sexual harassment, sexual assault? And this is very near and dear to your heart because you've seen how much it disrupted your sister's life. Maybe your father was accused of sexual assault improperly, falsely, and lost his job as a result. That might be hard to walk into an investigation and not have a tendency to believe the respondent. or believe that the complainant is just jumping on the Me Too movement. So again, awareness is key. Maybe the witness has the same mannerisms as your brother you do not get along with and find incredibly annoying. And the whole time you're interviewing him, you're like, oh my gosh, I wish they would just stop the way he's talking, the way his hands are moving. Just be aware this is my bias speaking, and don't let that impact your ability to objectively judge what someone's telling you. That's what association bias is. Okay? Confirmation bias is another type of bias. And again, we all engage in it, so making sure we are aware of it can minimize the impact it has on our credibility assessments, which is what we're going to be doing as decision makers. So confirmation bias is a natural tendency to give more weight to information that that confirms a preconceived notion or belief. For example, if you believe the boys will take whatever they can get from girls, you're going to walk into an interview and whatever is reported to you, you're likely going to believe the complainant more than the respondent, because whatever their complainant is telling you is just reaffirming what you already believe. Or girls who wear short skirts and midriffs are asking for it. They've likely consented to whatever they're complaining of. If that's your belief, it's fine, no judgment. Just know that that is going to impact your assessment of credibility as you interview. Even if you're not, as the investigator, making a decision, you're still going to be writing a report. And so as you write the report, you're going to be writing one way or the other that's going to lend credibility to the complainant or the respondent. Another belief might be boys will be boys and exploring sexual limits is part of growing up. Just is. That might be your belief. Again, so no, if that's your belief, walking into these interviews, you're going to have to suspend that belief during the interview and just be a blank slate and let information come to you. Or girls make things up and cause drama. So whatever the case may be, just be aware of what your beliefs are as you walk into an interview, suspend those beliefs, and try to hear what is being reported objectively. So that's confirmation bias. Here's another example. Confirmation bias can influence who you interview and what evidence you seek. For example, if you believe boys will take whatever they can get and the respondent is a boy, there might be a tendency to review the student's disciplinary record with a fine-tooth comb, even when it really isn't relevant. Who cares if the respondent was smoking pot? Does that support the complainant's allegation that he fondled her during art class? Maybe if you believe that girls like to make things up and cause drama, you might not interview individuals identified by a female complainant, dismissing additional witnesses as lacking credibility. Because you think, whatever this girl says and her friends say, it's just a lot of drama, so I'm not going to interview those people. So again, be aware that confirmation bias can impact not only your assessment of credibility of the person you're interviewing, but also who you might interview and what evidence you might review. Okay. Then we have a bias called like-me bias. And that's a tendency for an investigator to favor information received from witnesses who are, in some respect, like the investigator, right? So the investigator has a son who plays football, and the respondent plays football. There might be an unconscious tendency to believe the respondent because of the common bond of football. If the investigator is the only employee in the district who's not a member of the predominant faith, and the complainant is also not a member of the predominant faith in the community, the investigator may tend to believe the complainant based on the common bond of being an outsider. And again, none of these things disqualify an investigator from doing an investigation. They are just things to be aware of and to recognize as you go into an interview so that you can recognize and push them aside. And again, that blank slate is what you're trying to achieve. Another example, sometimes the very fact that the investigator is male can unconsciously lead him to tend to believe the male party, same with females. Doesn't disqualify anyone, would not be a basis of a conflict of interest. It's conflict of interest. The investigator was male, the respondent's male, no wonder it turned out in his favor. That won't fly, but again, just be aware of what's going on in your own head. Okay? Priming is another type of bias, which means a tendency to phrase questions in such a way that elicits a certain response based on the investigator's bias, again, either consciously or unconsciously. For example, what did you do when he attacked you versus what did you do when he put his hands on you like that? Do you see a difference? The first question is evident of the investigator's belief that the hands-on was an attack. This is an attack. This was, a boy putting hands on a girl, that's an attack. Maybe it's just a boy putting hands on the girl. So before assuming or identifying it as some language that supports your preconceived belief, think about how you can phrase the question in a way that simply restates the facts that have been presented to you. That's all. If the complainant said, he attacked me, totally fine to say, what did you do when he did that or when he attacked you? It's okay to repeat what someone has said, but when you're putting your own words into what someone is telling you, that might be you engaging in priming based on your bias. So do your best to just repeat the words given to you. Another example, how did you feel when you found out you were being stalked? Versus, how did you feel when you found out a complainant was following you? That stalking is a legal conclusion. That's the whole point of what you're trying to do. Did you need to determine whether there was stalking? That's why you're doing the investigation. So just asking the question in the way that it was presented to you is going to elicit the best and most accurate information. Okay. Any questions on bias and conflict of interest? That is a large portion of what these regulations are emphasizing, that investigations should be done objectively, absent conflict of interest, absent bias. The idea is we don't want anyone going into investigations assuming that the respondent is always guilty, or vice versa. So there are all-day conferences on conflict of interest and bias, but I think that the point is walk in with a blank slate. Walk in looking to discover what happened, okay? What happened? So, if there's not any questions, it's lunch. Is that lunch? Are we good?
Sure, but if you want to finish a part, you can, and you stop where you feel is a good spot to. And
Let's get through law enforcement. It's just one quick slide. We already kind of talked about it, and then we'll jump into some investigation techniques afterwards. Okay. Working with law enforcement. We talked a little bit about that already. Make sure you are developing a positive relationship with your agencies. Hopefully you already have that. This is going to come in handy in so many ways besides just Title IX. If you haven't, I know we're supposed to have training with SROs and admin every year. And if that isn't happening, maybe look at making that happen. But as part of that training, consider talking about Title IX and explaining to SROs. Yeah?
so Heidi, what we've done with that, you did that training for the board Teresa's.
Yeah.
We've taken that and published it on our website for school districts, and then we were going to every 3 years update and do it.
Great.
So it is on the CUTE website for
Great.
all districts to use that SRO training annually.
Okay, yeah, and that's great.
Yeah, and it
Just
has the PowerPoint and everything that we provided, but then we were going to like every third year update.
I believe Title IX is in, there's pieces of that Title IX in there, I think. If not, then just make sure you're having conversations with your SROs and say, hey, there's this thing called Title IX, and we have to investigate, even though it's criminal. Here's how we're going to walk through this. Let's decide now how we're going to walk through this. So have those open conversations. Again, CJCs may or may not allow detectives to listen in and document the interview in the police report. If they do, and the law enforcement agency will release that, great. If not, it is difficult. We worked with the CJC recently with another district where the CJC told the complainant, even before the school district had done anything, told the complainant, you're fine, the respondent will be suspended from school because this is really serious, and so, you're safe to go back to school. And the school district was like, we can't do that. And we don't even know what you was told because you won't, because they can't give us that information. So it was a little complicated, and we had to have a conversation with the local CJC that says, You can't be telling people that, because of course parents were very upset then that the school district didn't suspend the respondent. But in terms of that interview, if it is with the CJC and that's the only documentation of the interview, then you're not going to get a copy of it. You will likely have to interview the complainant again. Okay. So to the extent that you can avoid re-interviewing a complainant, try to do so, but that's not always possible. Title coordinator, Title IX coordinator, be patient, but follow up on a regular basis. These new regs allow us to delay our investigation if there's an ongoing law enforcement investigation. But like I said, that delay is only a delay that is reasonable. And so if the school is saying, well, I'm going to wait to see if the charges are actually going to stick. If the prosecutor charges and is a finding of guilt or a conviction of guilt, then I'll move forward. That's not going to work unless you live and work in a district that moves very, very quickly. Most of the time, these can take months, if not even a year or so, to resolve. And so the important piece that law enforcement really doesn't like is when principals get in and start interviewing witnesses before they get a chance to interview. Sometimes interviewing respondents before they have a chance, and suddenly the respondent knows about the allegation, and law enforcement is really frustrated. So once the investigation piece is done for law enforcement, we can get that report. At a minimum, you can start your own investigation. And it would be wise to document your contact with the agency to say, hey, just checking in, where are you, what's going on? Because we do have an obligation to do the investigation. But we can wait. We just need to make sure we're showing that we're not just sitting around doing nothing. Communicate regularly with the family about where law enforcement is at. Again, failure to charge or prosecute criminally doesn't mean that we don't have to investigate administratively. It is a totally different standard, a different process. Some prosecutor might decide that there's not enough evidence to sustain a conviction beyond a reasonable doubt, but administratively, you can absolutely determine by a preponderance of the evidence that this incident happened. So make sure that you're not just washing your hands of it if law enforcement says we don't have enough to prosecute. Yeah.
And I just want to point out, the last training we had with the AG's office, they were pretty pointed in saying that SROs were not to be involved in any of that investigative process. It was just the majority investigator doing their own. So they've had districts in the past where they had the SRO sit in with them.
Yeah.
And that actually did that, it created the bias and conflict of interest,
Yes.
even in that you had in the previous slide.
Great point. Yep, great point. It's fine if your SROs are doing a criminal investigation for their purpose and then you ask for their notes. But once you start your investigation, yes, once SROs get involved, there's a difference. The whole atmosphere of the investigation and the interview changes. So great question, great comment. Okay, let's break for lunch. Then we'll talk afterwards about doing investigation and interviews.